recap of conditions and warranties which we have started in the last class. When we talk about the conditions and warranties, so we say that whenever we talk about the contract of sale, be it in form of sale or agreement to sell, it is subject to certain terms and conditions, right? The terms and conditions are decided by the parties themselves. These are decided for the fulfillment of the contract, and if these are not fulfilled, so the purpose of the contract would be defeated. So when we talk about the role of the Sale of Goods Act, it says that there are certain terms and conditions which can be classified into conditions and warranties. Conditions can be express conditions and implied conditions. Warranties can be express warranties and implied warranties. So when we talk about the express conditions and express warranties, these are specifically decided by the parties and being communicated to the other party as well at the time of formation of contract of sale. So these express conditions and warranties would decide or would talk about the intention of the parties, the subject matter and the reason for which the particular contract has been entered into. So when we talk about the conditions and warranties, it is said that as per law, there are conditions have to be fulfilled. And if conditions are not fulfilled, then the law gives right to the party to set aside the contract and to even claim back the price if it has been paid by the party. So when we talk about role of Sale of Goods Act, it talks about that conditions are related to the main purpose of the contract of sale, and the warranties are related to the additional terms and conditions, but both needs to be fulfilled as per the law. But if the conditions are not fulfilled, the rights for breach of contract or rights for setting aside the contract is available with the party. And if we talk about the warranties, so warranties are the additional terms and conditions which needs to be fulfilled, and if these are not fulfilled, the party can claim the damage. And as per law, the conditions and warranties are implied conditions and implied warranties as well, which needs to be fulfilled. तो एक्सप्रेस कंडीशन तो पार्टीज डिसाइड कर देंगी, लेकिन इम्प्लाइड कंडीशन जो प्री डिफाइंड है विद इन द लॉ, विद इन द एक्ट, दैट वी हैव टू make ourselves familiar with. So if we say about the meaning of the condition, so we say we have already discussed that it is related to the main purpose of the contract. It is related to the subject matter or the purpose of the contract, and if not fulfilled, the purpose of contract of sale would be defeated. So as per law, breach of condition gives right to the party to treat the contract as repudiated to be set aside. Whereas we talk about the warranties, warranties are related to additional requirements, additional stipulation to the main purpose of the contract, which needs to be fulfilled. But if these are not fulfilled, the other party gets the right to claim the damages but cannot set aside the contract. And whether a particular requirement is a condition or warranty would depend upon the intention of the party at the time of formation of the contract and what is the purpose for which the contract is being entered into. So there we had discussed several examples where is in one contract the same requirement can be a condition, and in another contract the same requirement can be a warranty. So it would depend upon the intention of the party at the time of formation of the contract. Then we have already discussed the requirement and difference between the conditions and warranty. So I'm not going to take up again, but there was we left a point that was the treatment for the breach of condition to be treated as breach of warranty. Now in this particular case, just a second. Whenever we talk about the breach of condition, so breach of condition is going to give you the right to set aside the contract, right? And when we talk about the breach of warranty, breach of warranty can give you right only to claim damages. Now the rule says कि अगर आपकी वारंटी ब्रीच हुई है तो आप उसको ब्रीच ऑफ कंडीशन नहीं ट्रीट कर सकते. Can't be treated as breach of warranty. ब्रीच ऑफ मीन्स नॉन फुलफिलमेंट. तो अगर आपकी वारंटी फुलफिल नहीं हुई है तो आप उस केस के अंदर कॉन्ट्रैक्ट को सेट असाइड नहीं कर सकते. वेयर एज देयर इज ब्रीच ऑफ कंडीशन, तो conditions are for the benefit of the we can say buyer. So if there is a breach of condition, so it can be treated as breach of warranty. So उस केस में the damages can be claimed by the buyer, but he elect the contract to be performed. He is not willing to set aside. So as per his choice, breach of condition can be treated as breach of warranty. It is permissible by law, right? And the circumstances we'll discuss in detail at later stage. But if we talk about the breach of warranty, so it cannot be treated as breach of condition, that the warranty is not fulfilled and you have got the right to set aside the contract. It is not permissible. So this rule we have to remember. So here we have discussed that a breach of condition can be treated as breach of warranty under some circumstances, but breach of warranty cannot be treated or considered as breach of contract or condition, right? Now there come certain circumstances where condition can be treated as breach of warranty, but before that I would like to cover the implied conditions and implied warranties, right? If you will have any doubt related to any of the implied condition, you can raise your hand and you can ask the query. When we talk about the implied conditions are those which are given by law and which needs to be fulfilled. Very first condition is transfer of the ownership. So where the purpose of entering the contract of sale is the transfer of the property therein. तो वो कॉन्ट्रैक्ट ऑफ सेल तभी फुलफिल होगा, तभी वैलिड कॉन्ट्रैक्ट होगा जब उसमें आपकी ट्रांसफर ऑफ ओनरशिप होगी. तो ये इम्प्लाइड कंडीशन बाय लॉ है कि जो सेलर है उसको ओनरशिप बायर को ट्रांसफर करनी है, और अगर सेलर ट्रांसफर नहीं कर पाता ओनरशिप बायर को तो बायर कॉन्ट्रैक्ट को सेट असाइड कर सकता है, रेपुडिएट कर सकता है. तो उस केस में वो ब्रीच ऑफ कंडीशन मानी जाएगी और बायर के पास कॉन्ट्रैक्ट को सेट असाइड करने का right available hoga, because the basic purpose in the contract of sale is that ownership will be transferred from the seller to the buyer. Then there we had discussed about sale by description. तो जब भी सेलर अपनी गुड्स के बारे में डिस्क्राइब कर रहा है और बायर उस डिस्क्रिप्शन के बेसिस पे गुड्स ले रहा है, और उस केस के अंदर बायर ने गुड्स नहीं देखी हैं या गुड्स देखी हैं, बट ही इज रिलाइंग ऑन द डिस्क्रिप्शन गिवन बाय द सेलर, और जो डिस्क्रिप्शन है वो आप एज अ नॉर्मल ह्यूमन बीइंग या एज अ गुड्स को देख के उस चीज़ को जज नहीं कर सकते हो. तो उस केस में अगर गुड्स आपकी डिस्क्रिप्शन से डेविएट करती हैं, देन इट वुड बी ट्रीटेड एज ब्रीच ऑफ कंडीशन एंड द बायर हैज अ राइट टू set aside the contract. Another condition we have discussed, sale by sample. So whenever the sale has happened with by sample, then in that case it is the condition that the goods, the bulk must correspond with the sample, and if there is a deviation, the buyer has right to set aside the contract. और उस situation में the buyer should have reasonable opportunity to compare the bulk with the sample. For example, there I can take two examples. One example is that is one part of a machine. So you have selected a particular sample on the basis of which that suits that comes to be fit to the machine, and you have ordered for the same particular part which is to be which is required by you. So in this case, the sample you have tried that fitted well. Now the actual product when it has come, so it means that if you have received that particular article, so receiving that article does not make that it correspond with the sample. It must fit the particular machine for which it is being made, and if it does not fit, you have the right to set aside the contract because the particular thing has not is not matching with the sample. So this is one example. So a person should have reasonable opportunity to inspect that whether the particular bulk match with the sample or the particular product which you have ordered match with the sample are fit for the purpose or not. Secondly, there is the requirement that when you have accepted the goods, so that time you could not compare, right? So that time you were not having the sufficient opportunity. So now sufficient opportunity says that, for example, you have ordered certain rolls of the dress material, and you have selected certain shades which you are going to use for your manufacturing certain kind of dresses for a particular event. So now when the particular sample has reached at your place, it was in the month of October, it was 6:30 p.m. in the evening, and there was not the proper light or the proper atmosphere where the shades could have been matched. Next morning, when the buyer has checked the shades, so the shades were different as compared to the sample approved by the buyer. In this case, even the buyer has accepted the goods, accepted the delivery. The next day, when the goods did not correspond with the sample, the buyer has right to return those goods. So in this case, this is a very important condition that buyer shall have a reasonable opportunity of comparing the bulk with the sample. Then, if there is a sale by description and sample, so it must correspond with the both of them. And then we talk about the condition as to fitness or quality. When we talk about the condition as to fitness or quality, it means that whether the goods are fit for your purpose or not, are of a quality or not. So every person have different taste or different requirement. For one person, a good pen with a smooth tip and comfortable writing is of good quality, and for other person who requires a signature pen, the looks or the design or brand of the particular pen is important. So whether a particular requirement, particular product is of fit for your purpose or is of a quality or not, so in that case it would differ from one person to the other person. So it is your choice. So the person, the buyer, has the responsibility to see whether the goods are fit for his purpose or not. So in this particular situation, the doctrine of let the buyer beware applies. It means that if you are making a wrong selection, if you are buying a wrong product, then you cannot set aside the contract because you have made your own choice. But if you have relied on the buyer's skill and judgment, and you have very well explained the buyer the purpose of purchase of the goods, and buyer is an expert in the particular area, then in that particular case, the buyer's responsibility is not there because you have already expressed your requirement, your need for purchase of the good. The buyer seller is the expert in the particular area, and you have relied on the skill and judgment of the seller. So, if these three conditions are fulfilled, then the goods, if these turn out to be unfit for the purpose, then in that particular situation, the buyer has the right to set aside the contract. So, whereas we talk about the condition as to fitness or quality, there is this is a duty of the buyer to see to check that whether the particular goods are fit for his purpose or not, and if it doesn't turn out to be fit, the buyer cannot blame anyone else for the wrong selection or for the wrong choice. But in a situation where buyer has expressly or impliedly communicated his requirement and have communicated told the seller the purpose of purchase of the goods, and seller is dealing in the goods, expert in the area, and the buyer has relied on his skill and judgment, then in that case condition act of fitness or quality applies, and if goods turn out to be unfit for the purpose, then the buyer has a right to set aside the contract and even can claim the price back after the goods, the contract is set aside. And here I have shared the case law of Bhagati car, wherein the A purchased the car for the racing purposes, and he has communicated this to the seller, and seller has suggested one car, and the buyer has purchased that particular car for racing purposes. But the particular car turned out to be unfit for the racing purposes. Buyer had a right to set aside the contract within the meaning of law, because the condition as to fitness of the purpose has not been met. But otherwise, the exception is that when we talk about let the buyer beware, so this doctrine applies. So this doctrine we are going to discuss in detail, and exception to this doctrine in the next class. Then we talk about condition as to merchantability. So whichever goods are being made, if these are being sold in the brand name or some trade name, these are being sold off, then in that particular case, the particular purpose for which these goods are generally being made or generally being used, then in that case, it should be reasonably good. Means it should not defeat that purpose, or we can say that should not be of that purpose which is harmful as such. So this is called as condition as to merchantability. So if it is requirement that these goods are fit for the purpose for which these goods are commonly bought. For example, if we have purchased a shampoo, the purpose of the particular shampoo is to clean the hair, but when you have used the shampoo, your hair became more dirty. So it means it is not fit for the purpose. But whether this particular shampoo is for good for your hair, or suits your hair type, or gives good result or not, it is secondary. It is your decision. This is a let the buyer beware doctrine of caveat emptor applies there. But in general situation, whenever we are purchasing any particular product, it should be reasonably good for the purpose for which it is being made. But whether it is of a good quality, whether it is fit for your purpose or not, that would be different, and that is the requirement or duty of the buyer to take care of the particular good or fitness of the purpose as well. Condition as to wholesomeness we have discussed, that we talk about the merchantable quality or reasonable quality, and this particular condition applies with respect to the eatable items, and here we say that the particular product should not be harmful for the consumption of the person. So this is the condition, and if it becomes harmful or there is some loss because of that, then the party has right to set aside the contract. Then, in condition implied by custom and trade, we have discussed that as per the industry standard, if certain schemes, certain after sale service, guarantee, warranty, etc., is being offered, so these becomes the condition as per the custom and usage of trade, and these must be fulfilled. When we talk about the implied warranties, so warranties means that additional conditions, terms and conditions which must be fulfilled along with the other conditions of the contract. So implied warranties are those which are presumed by law, which must be fulfilled as per the contract. When we talk about the first implied warranty, it talks about the quiet possession of the goods. So when we say the contract of sale, we say that there is the requirement of transfer of property, that is the ownership in the goods. So in that particular situation, this transfer of property is a condition. If not fulfilled, the party has right to set aside the contract. But when we talk about the possession, so ownership can be transferred without possession of the goods. Documents of title can be given, railway receipt can be given, or any other ownership document or transfer document can be used for the transfer of the goods. But this can be done without the giving the possession of the goods. So possession of the good is also required with respect to the contract of sale. So if there is any delay in possession, or any difficulty in possession, or any other person has the encumbrance or the particular product is hypothecated, and you incur certain kind of extra expenditure to get the particular goods released or to deliver or to collect, in that case you can demand that expense, that cost of damage from the seller. So there is implied warranty that the possession of the goods to be given from the seller to the buyer, and in that case, if buyer's possession is disturbed by anyone having a superior title than the seller, the buyer is entitled to hold the seller for the breach of this warranty. So in that case, he can claim the damages to take back the goods, or any expenditure is being incurred, etc. That damage is to be borne by the seller himself. Then there is a requirement that goods should be free from any kind of encumbrances, hypothecation, etc. So if the goods are in charge of some other person, or any person has some right over the goods, then in that case the buyer has the right to get it released and to claim the damages from the seller for the same. Now, the condition warranty to disclose dangerous nature of the goods is very, very important warranty. In this case, if any damage is being suffered or any loss is being suffered by the buyer due to non-disclosure of the dangerous nature of the goods, then whatever loss is there, it is to be borne by the seller, right? So any kind of dangerous nature in the goods is to be disclosed by the seller to the buyer, and if the seller himself fails to do so, then in that case whatever injury would be suffered by the buyer, the seller is going to be responsible for the same. There is a case law that a purchased a bottle from the particular shop, and this bottle was required to be opened in a specific manner, otherwise it could be harmful or the bottle could burst. But seller has not communicated this particular information to the buyer, and it happened that when the bottle was opened, it burst and the hand of his wife was injured or burnt. So the loss had been suffered by the seller. The case has been filed, and it has been compensated by the buyer, compensated by the seller. Then the last condition is warranties implied by custom or usage of trade. So there are certain situations where the warranties can be given, and these needs to be complied with. Then there is a situation that says that exclusion of implied conditions and warranties. So if we say that under any contract there are certain implied warranties and implied conditions. So in that case, by express agreement or by course of dealing between the parties, if the usage of trade bind both the parties to the contract, so any under this it may be changed or negatived by the parties. So in that case we have to do the express agreement for the same. But no liability for implied terms can be excluded by express contract, by course of dealing, or by usage of trade. So sometimes we keep on having the goods in the name of the other owner, or we keep the goods with the other person in possession. So if we wish to exclude the implied conditions and warranties, then in that particular case there is the special agreements between the both the parties with their mutual consent, and this can be further taken care of. Then after this, now we come to the topic breach of warranty to be treated as breach of condition, and breach of condition to be treated as breach of warranty. Yeah, there are two things. One, condition to be treated as warranty, and other one, breach of condition to be treated as breach of warranty. So there is one possibility. Uh, Not able to write here. Okay, no problem. So in one situation, the condition which has been decided by the party, the contract has not been performed, breach has not been committed, but the condition is treated as warranty by the buyer. For example, the example which I have given to you, that A has ordered a red color car which was to be delivered before 30th of June. Now in this case, the red color and the requirement before 30th of June, both are the conditions, the basic requirements. But the breach of condition कब होगी कि अगर seller इस कार को दूसरी कलर की कार को 30 जून से पहले भेज देता है. So it means that there is non-performance. But prior to this, if the seller gives a call to the buyer and say that you need a car, red color car before 30th of June, but the red color will be available after 1 week, so I won't be able to deliver it by 30th June. So he wants to give surprise to his wife. So he, waive off this condition, red color. So in this case, condition is treated as warranty, right? So it means that the conditions, the terms are for the buyer's benefit, for his choice, and he can set aside the contract. But if he wish, he can himself waive off the condition, and once the particular contract is performed and there is breach of condition, and the buyer accepts the goods and accepts the goods despite of that breach, then in that particular situation, the breach of condition would be treated as breach of warranty, right? So in this case, under what circumstances breach of condition to be treated as breach of warranty? One, voluntary waiver by the buyer, that he himself waive off the particular condition. Second, election by the buyer to treat breach of condition as breach of warranty means that the breach is committed and he has accepted the goods. So in this case, once he has accepted the goods, he is bound by the contract. He cannot repudiate it later on, that I have, he has accepted the car, the white car, and he has gifted the car, and after giving as a gift, after that day or after next week, he visits the seller and say that I have ordered the red color car, so you have to change it, else you take back your car and give back my money. It cannot happen. So once the breach of condition is treated as breach of warranty, it means that the buyer can treat the contract, if he wants to, set aside the contract, or he wants to treat the contract as repudiated, then in that case he needs to reject the goods. But if he has accepted the goods, then in that case he cannot set it aside later on. So it means breach of condition is treated as breach of warranty, right? Next is acceptance of the goods by the buyer, we have already discussed, right? And acceptance only part of the goods. So if the goods are indivisible and you have accepted part of the goods, you have to accept whole of the goods. But in case the goods are divisible, then in that case the buyer has a right to repudiate or to reject the remaining part of the goods, right? And when we talk about the meaning of acceptance, so meaning of acceptance means that he informed the seller that he has accepted the goods. He does anything which is inconsistent with the ownership of the seller. For example, consume the goods, use the good, pledge the goods, or resell the goods, or after a reasonable time he retains the goods without intimating the seller that he has rejected them. And express conditions and warranties are those which are expressly provided in the contract, and implied conditions and warranties are those which the law implies into the contract unless party enters into a contrary conditions or go for the different conditions as such. So from my side, the topic of conditions and warranties, from meaning, importance, express conditions, implied conditions, breach of condition to be treated as breach of warranty, condition to be treated as a warranty, or acceptance meaning. All these things we have discussed in this particular topic. If you have any specific query, we can discuss this. And my dear friends, in the Sale of Goods Act, the first chapter, which we have discussed about the meaning and requirements of the contract of sale, there comes the half question. Second topic is of conditions and warranty. Third is doctrine of caveat emptor, and there is the transfer of ownership by the non-owners and the exceptions for the same. And the last topic, rights of unpaid seller. So I think these I have three half questions, and the one question can be, means out of this you are going to get to one complete question for 15 marks. But these kind of situation where condition can be treated as breach of warranty or not, or what are the requirements, so you need to understand different examples, different circumstances and situations, which will help you to attempt the particular question in the exam in a better way. So if you have any queries related to these topics, we can discuss the queries. Else we can